As we said, the procedure of individual petitions is one where a state, a person, a community, or an NGO complains about a state's violation of a human right established in an instrument over which the American system has competence. A simple case for sending before the Inter-American system would be one where there is a statute that enshrines some kind of racial discrimination. In that case, if a domestic court applies this statute, it would be violating human rights, even if it follows due process. Therefore, the state would be easily condemned. A paradigmatic case before the Inter-American system, or let's say an unfortunately common case before the Inter-American system, would be one where the state forcefully makes a person disappear and the domestic courts didn't investigate the matter because of the existence of an amnesty law. There are many cases like this before the Inter-American system. It is important to note, though, that the Inter-American system does not perform as a fourth instance. What does this mean? Well, that the Inter-American system does not exist for complaining that a domestic remedy didn't fulfill one's expectations. In other words, it's not an appeals chamber. Hence, a person should not complain before the system if he or she considers that a domestic court made an incorrect assessment of the facts or interpreted the law in a way that the petitioner didn't like, unless the individual considers that in doing so, the domestic court violated due process or another human right. An example could be one where the petitioner asked the domestic court to evaluate some evidence, but the domestic court didn't even look at it, in which case the applicant may claim that there was a violation of his or her right to due process. Another example could be if the executive branch controls the domestic judiciary and it presses in order to acquit a violator of human rights, and in that case, the judicial procedure is a sham in order to reach the desired outcome. Now, how do you lodge an individual petition before the system? We should remember that the Inter-American Commission is in charge of initially processing petitions. In fact, the Commission will be the only body in charge of processing petitions when states have not given jurisdiction to the Inter-American Court. Do we need to travel to Washington, D.C. to lodge a petition? No. It's enough to go to the website of the Inter-American Commission and submit the petition. The Commission will only decide cases where it has competence according to the place, the matter, time, and person involved. This means that the petition must fulfill 4 basic requirements. First, it has to have competence according to the place, meaning that the violation of human rights was committed in the territory of a state party to the OAS Charter or in a territory that is controlled by one of these states. Second, the Commission must have competence according to the matter, which means that the state must have violated one of the rights established in an instrument over which the Commission has competence. That is, mostly the American Declaration on the Rights and Duties of Man or the American Convention on Human Rights or some other treaty granting it jurisdiction. Third, the Commission must have competence according to the time. That is, that the violation must have been committed while the Declaration or the Convention were in force in a particular state, because international instruments are made for being binding only for the future. The court has interpreted this saying that it doesn't prevent the system from analyzing cases where the state doesn't grant due process for remedying these old human rights violations. Fourth, the system must have competence according to the person. Basically, this means that the victim must be an individual or group of individuals, but not a legal person such as a corporation or an NGO. The sole exceptions are when this legal person is an indigenous community or a labor union or some other institution that may show a very tight relation to a particular right, as it may be, for instance, a radio broadcaster that is claiming the protection of its freedom of expression. The court developed this requirement in its advisory opinion number 22, so there you can learn a little bit more about it. Well, in addition to these 4 competence criteria, petitions must fulfill the admissibility requirements, which are established in the Rules of Procedure of the Inter-American Commission and in the Inter-American Convention. Some of these requirements are pretty obvious or easy to fulfill, but I think that the admissibility requirements that need to be pointed out are, first, the obligation of exhausting domestic remedies before lodging a petition. This requirement exists because the international system of human rights has a subsidiary nature, also called complementary nature. So the Commission may analyze a case only if the state hasn't solved the problem. This requirement has exceptions, as it happens when there is no available remedy, or when the person lives in a country whose tribunals are not independent from the executive branch, or when there is evidence that domestic remedies are systematically denied. Another exception, which is very much used, is that a person may lodge a petition before exhausting local remedies when these remedies are taking an excessive or unreasonable time. The second admissibility requirement that I think is necessary mentioning is the requisite that the petition is lodged before 6 months have elapsed after the notification of the final decision of the exhaustion of local remedies. Once you are sure that you fulfill these requirements, you can lodge the petition. The way of doing it is through the internet. It's very easy. You just go to the website of the Inter-American Commission and go to the section Present a Petition. Once there, you go to a square that says Enter, and that's it. Petitioners don't even need an attorney to file a claim, even though it is, of course, better if they are represented by one. Once the claim is lodged, the Commission will engage in what is called the initial processing of the petition, where the Secretariat of the Commission will do a preliminary assessment of the petition's admissibility. The Commission doesn't engage in a system of docket control, even though, as we shall say in a moment, the number of cases is higher than what the Commission is able to process, so it may be unconsciously or in practice doing a docket control. Once the petition passes the stage of initial processing, which may last for a long time, the Commission will notify the state and will carry out a full study of the petition's admissibility. Once the Commission declares a case to be admissible, it will begin studying the merits of the petition. During that time, the parties may reach a friendly settlement, and perhaps that is advisable, which can end the case if the state adopts all the measures that it agreed with the petitioner. The case may also finish for reasons such as the petitioner's abandonment of the process. If not, the petition should end with a final report, where the Commission will decide whether there was or not a violation of one or more human rights recognized by the American Declaration, the American Convention, or some other treaty granting jurisdiction to the Commission. If the Commission decided that there was a violation, it will recommend the state taking some measures. If the state did not ratify the American Convention and grant jurisdiction to the Inter-American Court, the individual petition will end there with a non-binding report that the state may or may not fulfill.